Yes, Ms. Bester.
It was suggested and we agreed upon us that we would start then on the 10th of February with the calendar, up until the end of the term.
Mm-hmm.
And then already the third term, my lord, we're going to utilize the third term. Mr. Jiva is not available for the second term.
The entire second term.
We tried a third. And my lord, I would request already at this stage the question of funding. Are they in a position to proceed with the matter and to finalize them? Otherwise, in the middle of the trial, they don't have any funds and we are then at postponement.
Yeah, I assume that implicit in the indication that they are ready for trial also means that they have the necessary financial instructions. Let me hear from all the parties. Ms. Bester has a particular request with regard to your financial instructions. You all have the necessary financial instructions to deal with the trial and be present until the matter has been disposed of. I think that's Ms. Bester's concern. Mr. Lamini, let me start with you. Mr. Kamedi, you will then follow. Mr. Diba.
Thank you, Madam. Let me first say the following before I come to the issue of financial instructions.
Okay.
But I remember before we adjourned, I am the one who said, I have been provided with the docket, provided with the indictment.
Yes.
Had sufficient time to consult.
Yes.
And in anticipation of being trial readiness.
Yeah.
But my Lord, there is an issue which I also need to place it on the record, and it is my instruction that I must place it on the record.
Mm-hmm.
It relates to the situation of number one. My Lord, there was an application in the High Court where number one was challenging, amongst others, their arrest as well as the jurisdiction of the court to which she was appearing to say she was unlawfully before court. As
Okay.
a result of which the application was not successful, but she successfully petitioned the SCA.
All right.
But I want to bring it to attention that that application at the SCA, accused number one has already filed the papers. The state, which is the NPA in this instance, it is also one of the respondents there at the SCA. So the matter might be heard at any time, perhaps even before end of 2024.
Nice.
Which in my own way of thinking, it will also have a bearing on the issue of the trial. As much as I said, in anticipation of the trial, I am ready. I have done everything that is expected of the defense counsel to do. I have done it. But there are those rights which number one is exercising outside the forum where we are sitting now, which might have a bearing on this particular case. So perhaps if we are to postpone this matter for a trial, but we should have that at the back of our mind that as much as we postpone this matter to that particular day, but anything and everything is possible. Not unless if we may also put it aside and say, how about the issue of looking at another provisional date so as to look at whether or not by then when we come back the proceedings will be finalized at the SCA. I understand my Lord emphasized the fact that this matter also has to see its way into the trial court, which we fully agree with. But there are those issues which are still pending, which number one is still busy with, and where she is still exercising her right. And it is our belief that the SCA would not have accepted this particular matter to be heard in the SCA if there was no case to be argued there. fault by my earlier submissions that I have done everything in preparation for this matter. If I were to start a trial, I would be ready, but however, due to those factors which are beyond to me, which I actually wanted to. In a nutshell, my lord, the issue of a criminal jurisdiction, it has been challenged, it has been raised in a forum outside this particular potential really on this particular.
Thank you.
I'm not sure if my lord has got anything on it.
No, let me hear what Ms. Bester has to say about it, and because I hear you saying that that matter might be completed by the fourth term in the SCA. Because you filed papers, I want to know whether, or do you know whether they have filed papers, but I'll clarify that with Ms. Bester. Ms. Bester?
I should give support, the DPP Free State Society is one of the respondents.
Yes.
And the papers must be filed, our papers must be filed by the 5th of August, and it's also going to be Advocate Snellenberg and Advocate Mr. is appearing in that matter. But, I don't think we must jump the gun about the judgment there. The trial date, we must still proceed with the trial date. If something happens in the meantime, I think we can sort it out and make decisions in that regard, because if we don't set the trial date now, it's really going to take, we're going to go for another year before we can start. So my suggestion is still that if they're successful, it's going to change the situation, but if they're not, we can start.
Yes, assuming that they are successful, that will only have a bearing on accused number 1, if I understand it correctly. And if they are not successful, it will have no impact on the trial date, unless, of course, they take it further than the SAA. Yeah, thank you. Are you averse to the suggestion that we keep the trial date, Mr. Dlamini? I understand your sentiment, and it's sensible, it's reasonable, but if the chances are that the matter will be heard in the SCA during the fourth term, let's rather wait for then, and if for any reason you get an indication that it will be heard, let's say in the second term, after the date that you have tentatively arranged, then we can always arrange that this matter be postponed to a date further down the year.
Can I take this question?
Yes, yes.
My instructions are that we are not acceding to the criminal jurisdiction of this particular court. But however, we do not want to be seen to be standing on the way for the trial date to be set. We can still set the trial date.
Yes.
But in a nutshell, as a matter of fact, we are not acceding to the jurisdiction of this court, but it will be subject to the outcome of the judgment at the sea.
That is how I understood you the first time
Yes.
around.
That is the position.
Good. Anything from any of the other legal representatives? None. Mr. Moyle. Yes, no, we'll deal with your application, because your application does not have a bearing on the other accused, not so.
Yes, but on the readiness for trial, remember now it's all of us who are asked whether we're ready for trial.
Yes.
Could you talk about
Yes. Oh, okay.
I just wanted to place it on record that we are not in a position to run trial as we speak or trying to consult it, but to be that within due course, but just to place it on record.
Yes. And that is in any event the subject matter of your application, not so?
Exactly.
Yes. But I would not want a situation where I keep on postponing this matter and requesting the other accused to come to court at great expense, because they must pay their legal representatives each and every time when they come to court. They also have an interest in the finality of the matter, like you have and Ms. Bester has. Yes. So we will endeavor to get the matter trial ready as soon as possible, taking into consideration your application, of course. We will deal with your application in due course. Thank you. Yes, which accused are in custody? It's 1, 7, plus 8. Yes, the matter is now postponed until the 10th of February 2025. Accused numbers 1, 7, and 8, you are in custody. The rest, your bail is extended. You are warned to appear again in this court at 9 o'clock in the morning. Yes, Mr. Mola, your client will remain, and so that we hear your arguments with regard to the further prosecution of your application. Because it's just a matter of the filing dates, and then I'll give directions as to when what must be filed, and in any event, you can do it in terms of the practice rules of this division. But yeah, thank you. The accused may stand down except number 7. Let's just wait for them to. Yes, thank you, Ms. Bester. You're excused, Mr. Snellenberg. Yes, you're also excused, gentlemen and lady. Good. Yes, Mr. Moyler. Okay, no problem. Look, the application, as I informed you, is not ripe for hearing, as things are, because you indicated that you would like to consult with your client and then thereafter file a replying affidavit. Not so. Yes. Yes. Mr. Snellenberg has also indicated that regardless of the flaws in your application, they would take a pragmatic approach and have the matter argued as soon as it is ripe. Mr. Snellenberg, I see the state is the first respondent. I assume you're also appearing on behalf of the state, whoever and whatever that is. Then there is the National Commission of Correctional Services, the head of the center at Kgosi Mampuru, and then the Minister of Correctional Services. All the respondents. Good. Thank you. Yes. Mr. Moila?
Thank you, my Lord. As we briefly discussed in chambers, the only issue that we were at variance was the issue of which forum. This we are not going to deal with the merit. Which forum should adjudicate this matter?
Mr.
A criminal court?
Yes.
A civil court. So, the starting point here is that you must just place your record.
Mr. Moila, I suggest that you deal with the relevant issue at this stage, and that is the fact that you have not yet filed a replying affidavit. It will not help you to argue anything in front of me now, when the matter is not ripe for hearing. Any arguments that you want to bring with regard to jurisdiction or anything else can only be entertained by me or any other court or any other judge that I assign the matter to when the matter is ripe for hearing.
Madam, I thought our understanding from chambers was that the allocation of the matter, whether it's going to be held in a criminal, remember it has an impact of whether the accused will be in court or not. If it's going to be held by a civil court, may I just finish, Madam?
Yes, do.
If it's going to be held in a civil court, the accused is not required to come in terms of the criminal. In fact, it's not even in terms of the criminal procedure and what is there. But if it's held by a criminal court, he is entitled to be here when the matter is there. And my understanding from the discussion in chambers, and that's why I then say that this would be something that will be ventilated in court, that the issue of the forum, in fact, it has nothing to do with the replying affidavit, because in the answering affidavit, it's the parties are adding that the criminal court should adjudicate this matter. They've already replied. Remember, we advanced the issue because the respondent agreed that this court has jurisdiction. So the setting down of the matter, it's very important, whether in a civil court or in a criminal court. Otherwise, I would not have even asked this court to adjourn if that was not an agreement in chamber.
Mr. Moila, you brought this application as a civil notice of motion. It is for that reason that you have asked for cost orders against the people that you have cited. It is for that reason that you have cited all these people. And as you can see, Mr. Snellenberg, who appears on behalf of these respondents, is not the prosecutor in the matter. If you desire to bring a application in the criminal court, you are free to do so without asking for civil remedies like cost orders, unless you can tell me which section in the Criminal Procedure Act deals with cost orders in a criminal case, except of course, for the cost order section that is not yet in operation, section 142A, capital A. One, and then two, you decided to come to this court via this route. Three, if the matter is going to be argued on the papers, you are still going to file your reply, you will file your heads of argument, Mr. Snellenberg will appear on behalf of the respondents, you will appear on behalf of the applicant. If your application is premised on the accused being present during those arguments, I can see no reason why he should be present, and I can see no prejudice to him, because you say you want to consult with him so that you can file your replying affidavit. So if you think that you want the case locked into the criminal stream because you want your client to be present, then, Mr. Moeller, I can tell you now that if that is your game plan, it is the wrong game plan. Because Section 158, subsection 1 of the Criminal Procedure Act deals with the presence of the accused in criminal proceedings. And that is not what you brought here. Yes, please do.
Your Lordship will then realize that all these questions they've been answered by case law. I'll have a small excursion that in that excursion I will reduce my voice and elevate the voice of the case law.
Yeah.
Yes.
Good.
Then we start, because that question itself obviously is the issue of forum. So let me start by the court case of this division. In the case of Mukesi, if I'll give the Lordship the reference. In the case of Mukesi of this division, reference Mukesi versus Mukesi and others versus S. 2022. May I just give the reference number? That case, my Lord, dealt with the instance wherein the accused is Mukesi and others versus S, case number 45/2021, is the authority of this division. The accused person left the criminal court to a civil court. Exactly what your Lordship is suggesting. To assert their Section 35 right. Exactly what the accused in this court is asserting. Section 35 right of the Constitution. Is your client asserting a Section 35 right? Yes. On your paper, sir? I don't. You see, that's why I say maybe you should file your reply, and then we deal with the matter. When the matter is ripe, you can then argue all these things that you want to argue. The judge assigned to the case will then deal with it. You see, what you are asserting in this case is there has been a cascade of failures by everybody concerned, from the police who keep the accused to members of EST, I don't know what that acronym stands for, to the National Commissioner of Correctional Services, in the way he is kept, the way he is transported, what he eats, who must prepare his food. Now, I don't see Section 35 dealing with those issues. The closest that you come to Section 35 rights is under Section 35(3)(e). When it comes to him being present during his trial. Now, but the fact that the chef that prepares his food must write his name and surname down before giving him food, is that a Section 35 right, sir? My Lord, let me just be frank. With utmost respect, that's an oversimplification of this.
No, but the thing is, you are saying all your prayers are all in terms of Section 35 rights. But I'm saying to you, you stray far beyond Section 35. And the case law that you are referring me to does not help you. One. Two, If you want to argue an accused fair trial rights, the criminal court is the place to do so. But now you stray beyond that in this application, you see. And that is the simple point in this matter. If you reply and you consider your cause of action properly, you can then approach the judge who will be dealing with the matter and argue all these issues that you want to argue. The judge will then make a ruling at that stage. I am not going to make a ruling in this matter on a half-baked case at this stage, Mr. Moila. That is how simple it is. The case is just not ripe for me to make a ruling even on this point. That's how simple it is.
If your Lordship could exercise some level of patience for me to make a point.
Make it.
At the very least, to make a point. Then your Lordship can then have this comment after I've made a point, because we've reached a situation where now it's one-sided. I can make a point.
Make your point.
And proceed before I finalize the point. These papers say exactly opposite what your Lordship are saying they don't say. The other things, when you deal with the constitutional rights, the fact that you have a fair trial right in Section 35 does not mean that the same conduct cannot violate your right to dignity. Does not mean that it can violate other rights. That is the interrelatedness of the violation of the right. So your Lordship, what your Lordship does goes to the tail end of our application and focus on other minutiae of the rights and ignore the causa. When your Lordship will read our papers, we start, and this is what we say in paragraph 10 of the application. We say, I'm going to read it, because now what your Lordship is trying to do is create a situation as if like we don't know what we are doing and we are informed by the law. So it's very important to also place validation here. Paragraph 10 of our funding application, this is what it says. The ground norm or the fundamental basis of the application is Section 35, 1A, 2B, 2E, 3B, 3E, 3H of the Constitution. Right? I'm advised that the observance of this, and when you look at this, all this provision, they deal with the speedy trial, they deal with the right of consultation, they deal with the right of legal representation that is effective. And we know when you determine the issue of jurisdiction, you look at the pleadings, the founding papers, what they say, and that's a principle in Thabo. You don't even look at the merits, so you don't even have to wait for the reply, because the founding papers tells you the right that the accused is asserting. The reply, he can't even make the case in the reply. He has made it in the founding papers, and it tells you that it's Section 35. It goes on to say that I'm advised that the observance of the provision in Section 35 of the Constitution highlighted in the preceding paragraph would guarantee my right to a fair trial. Then this is what then your Lordship concentrated on, what I call a tail end of what we are arguing on our papers. In Section 35 of the Constitution, I employ this court to adopt an intersectional analysis of other constitutional rights. Then your Lordship speak about the food and all that. That is the intersectional analysis. You can't look at one right in isolation. So these papers, as they stand, they assert not any other right. They assert Section 35. The fact that it's complaining about the right to dignity does not remove the jurisdiction of this court. That's what it says. And that's the principle of the Constitutional Court in Thabo. You look at, and in fact, what you must really do, you must accept that this version is true for the purpose of jurisdiction, even if he can lose on the merits. And that is important. So it's unfair for the accused person who comes to court to assert Section 35 and is told because now he has raised the issue of torture. It's a fact that he's been tortured. They don't dispute that. They simply say that they are allowed to torture him in terms of the Correctional Service Act. The torture is not disputed. It's not disputed that he's incarcerated for 23 hours a day and only given 1 hour of exercise. They simply say that the act in terms of the Correctional Service Act. I can't, as a practitioner, remain supine when I see those violations, because ultimately, and this will then be argued in due course, ultimately and cumulatively, this would affect his mental health. So by the 10th of Feb, you might not have accused number 7 mentally fit. And that's what the case law says. So it's very important that we contextualize this case and do not concentrate on the minutiae of other rights.
Are you done?
Yes. That is the point that I was making. So it's
I-
clear that the papers say the opposite of what your lordship is saying.
Are you done?
Section 25 and all the subsection. The issue of him being here, it's the 158 of the Criminal Procedure Act that says every criminal proceedings, he must be here. He's entitled. I don't have to motivate that what papers that is served. That's a legislative entitlement. And there's a plethora of cases to that effect as well. And the reason why I wanted to start with Mukesi, because I thought maybe it would be given some elevation because it's a decision of this division. But there are cases specifically that says that it matters not. Because last week, what you were told that this is, we use a notice of application or notice of motion. A plethora of cases that have prosecuted the application through a notice of motion. In fact, it's even encouraged. It's even encouraged so that it can facilitate the proceedings. The reason you see the respondent being here is because they were invited properly and they came here in terms of the invitation. Otherwise, if we adopted a process working, we don't know what we are doing, we would not be having a respondent. So that's important for me to place it in context. And that's why I say that in the setting of the matter down, the issue of jurisdiction would be determined by the criminal. Where in the criminal court, it can be taken to a motion court or a motion court to determine it. It's this particular court that must even determine its own jurisdiction. If we are wrong on that aspect, then the court will chase us and will gladly leave, knowing very well that we are living, but on the wrong side, we are living with the right side of the law. Because all other cases support our proposition. Then we can then assist the accused to prosecute someone. But truly speaking, and with utmost respect, it is unfair to select certain paragraphs in the affidavit and we elevate it and we say that this application is about that. When the applicant himself says that the entire application is about this aspect, the rest of the aspect, he's inviting the court to adopt an intersectional analysis, which is not a foreign concept in our constitutional dispensation. I will not take this argument further than that, but I just wanted to place it in context. It will be argued in the fullness of time, but that fullness of time must happen in a criminal court so that we can ventilate it properly and not be subjected to the strictures of motion court.
Are you done?
Yes, that is my submission.
Mr. Snellenberg?
Thank you, Thabo. I just confirm my feelings with all the respondents. Let me make this clear. I don't know on what basis my learned colleague just made a statement that the state of military torturing is the best. Take exception to that. Secondly, the application that was brought on motion, Mr. Lester has testified on oath that day, and he will do so again in replying at today. So why he needs to be present when we motion is moved, I do not know. I selected to bring interlocutory applications, I turned it. But the issue of jurisdiction can be dealt with when the matter is fully ventilated. We were not told that we were going to argue jurisdiction today. We were not prepared to do so. And there is no need. This is a pre-trial court at this stage, during a criminal pre-trial. So all these issues that my little colleague has raised, we can raise before whatever forum this matter is placed in. And we can regulate it, and the court can decide and make a ruling. That is, we follow the pragmatic approach model, because we feel in matters such as this that doesn't assist anybody to waste time on technicalities. And lastly, we admitted that the High Court has jurisdiction. So we mustn't twist and read out of context. We're going to have serious problems with each other if we start reading.
Yes, thank you, Mr. Snellenberg. Any reply to what Mr. Snellenberg has said?
Just one point, the jurisdiction, paragraph 59 of the answering affidavit. When we raise the issue that this court has jurisdiction, it reads as follows: when they accept that this court has jurisdiction. While the respondent, they say they don't take any issue. While the respondent do not take the issue with the jurisdiction of this court to determine the applicant's complaints, it is important to highlight that the Act and the regulation make provision for complaints and request procedure to address inmate grievances. So now, they don't dispute the jurisdiction of the court. They simply speak about the other process that need to be followed. So they can't come here and all of a sudden be opportunistic and then say that we did not say anything about the jurisdiction when they said in their answering affidavit. That is but in respect of other submissions that we take no issue. We are willing to argue this case at an appropriate time when the pleadings are closed, but it must be clear that in the criminal court.
So why did you now argue all along if you are now saying this matter will be argued in the fullness of time when the pleadings are closed? Because that is what I've been trying to impress upon you from the beginning, from the first time that you stood up to try and argue this matter. Because even on your own argument, sir, on your own argument, firstly, I told you the last time around, if anything, these papers before me are not proper. At the time, these papers were not served properly on all the respondents. 1. 2. No days were mentioned to them as to when they should answer to your papers. 3. The people that you have cited, I mean the state, it's the first time that I see the state is cited as an entity. Then, because there are certain members of the executive who are responsible for certain state actions. Then, sir, your application, for an example, and maybe I should read it to you, so that you start thinking about your application, and maybe, if so advised, look properly at it and see whether it deals with Section 35 rights exclusively. Paragraph 1, you say, of your notice of motion, declaring the conduct of the second and third respondents in refusing applicant meaningful consultation in preparation of his matter to be unconstitutional and invalid. Paragraph 2, declaring the conduct of the second and third respondents in refusing the applicant's request to use a laptop, tablet, or any suitable gadget in preparation of his case to be unconstitutional and invalid. Then, declaring the conduct of the second and third respondents in refusing to make reasonable provision or accommodation for the applicant to consult in person with his legal representative to be unconstitutional and invalid. For the duration and in preparation of his criminal case, directing the second and third respondents to afford the applicant the following: an in-person consultation, allow the applicant to use a tablet or a laptop or any suitable gadget. Declaring the conduct of the second and third respondents in keeping the applicant in solitary confinement for 23 hours a day to be unconstitutional and invalid. Declaring the second and third respondents to remove the applicant from solitary confinement and keep him in a normal cell. Declaring the conduct of the second and third respondents in bringing the applicant to attend his criminal case hand and leg cuffed to be unconstitutional and invalid. Directing the first and second respondents to desist from hand and leg cuffing the respondent whilst in court. Directing the conduct of the first, second, and or third respondent in bringing the applicant to attend his case in violation of Section 9, 10, 12 of the Constitution to be unconstitutional and invalid. Pending the determination of the above prayers, the pre-trial be set down for the 24th of July, which has come and gone. Further alternative, and pending the determination of the above, prayers 4 and 6 and 8 in the notice of application apply forthwith as an interim order. The first and second respondents be ordered to pay the cost of this application on an attorney and client scale for counsel so employed. Then, in the affidavit itself, you say that you've made out a case for an interdict. Firstly, and I will read it to you. You say, I am advised that, or your client, in order for the application to succeed regarding the final and or interim relief, that I am seeking the application has to meet the following requirements: that I have a clear right that is worthy of protection for a final interdict, and a prima facie right, even though open to some doubt, for an interim relief. Now, it's not even clear whether you're asking interim relief or final relief. Then you say that there's a reasonable apprehension of harm, or harm has actually occurred. That the balance of convenience favors the granting of an interim relief. Can you see what I'm talking about? Now, I'm saying to you, Mr. Moyla, that I'm not going to enter into a debate with you about this issue again. I'm saying to you that your prayers, firstly, are civil prayers, and secondly, they stray far beyond the Section 35 rights. Now, you file your replying affidavit, and you act in terms of the rules of this court, and this matter will then be set down. A judge will hear the matter, and the judge will then decide. If you want to argue to the judge that the matter must be postponed, he must make, or she must make a ruling that your client must be there at that stage when you make your arguments, you are welcome to do so. I am not going to entertain an argument now on this half-baked application. Complete the application, complete all the papers, do what you must do in terms of the law, and then you can come back to me. All right? No, you may not speak. You have a legal representative. Yes. You can hear what he has to say. Pardon? You say?
I'm saying that I'm giving you an opportunity to write
Yes.
instruction, and I'm
Yes.
giving your lordship so to understand, because this is the person that is suffering. So when he sees this engagement, obviously he's triggered. So I'm asking your lordship to please.
No, there's no problem with that, but I will not allow him to speak because you are here to speak on his behalf.
That is correct, my lord.
Yes.
But I don't want to go back and forth on this. The issue here, the only issue here, is when the presiding officer purport to make ex parte comments and purport to prejudge the application and not allow the practitioner to comment.
The application will be ventilated in front of another judge at the opportune time, sir. Then you can ventilate all these issues. Mine is to get this matter trial ready. That's my task. If you want to argue all these things in front of the trial judge, you may do so.
What I'm simply saying that, my lord,
Or the judge that will hear the application.
it is in any circumstance, it is unfair for a presiding officer to make ex parte comments prejudging the matter and not give the practitioner to comment on that. And that's why I responded to that. Your lordship,
To comment on what, sir?
your lordship gave me a list of questions. When I was answering the first question, your lordship then interjected and not allowed.
Are you going back there now?
No, but I'm just.
What is your point, Mr. Moyla? What is your point, please? I fail to understand the point. I've been repeating myself over and over again, and you've also said you'll ventilate this point at the opportune time. Now, this is not yet the opportune time. That is how simple this whole issue is.
Can I make the point that your lordship has asked? Because your lordship has asked what is your point, Mr. Moyla. The point that I'm making, when I stood up, the lordship gave me a list of questions. Address this, address that. On top of that, the lordship made comments about our application. And then in addressing those questions, I brought to the court's attention that actually what this court says is opposite to what our papers say.
But then I've read the papers. Yes.
Then my learned colleague then responded. Then I said, in that circumstance of his sensible suggestion, there's no need to say anything further because he didn't say anything that is worthy of responding because he didn't invite me. But when your lordships make comments and invite me, I'm entitled to respond.
But sir, you said to me, you brought your paper. The things that I have said to you are selective. I've read your entire application or prayers to you. And I'm saying to you, like I said earlier, they stray, in my view, beyond your Section 35 rights. And I do not want to enter into a further debate with you. Make sure that you file your replying affidavit Make sure that you file your heads of argument in terms of the rules of this court. A judge will be assigned to deal with the matter, and that judge, you can go and ventilate all these things in front of the judge. I will assign a judge to listen to your entire argument, even on the jurisdiction issue. Everything that you want to ventilate, that judge will hear when the papers are ripe, sir. That's the only point. The papers are just not ripe.
That point is accepted.
Precisely. Now, if that point is accepted, I expect you then to sit down. And yes, then the matter is over. You took an instruction from your client. Is it relevant? Do you want to ventilate that instruction or not?
Yes, my lord, his concern obviously is the concern that I'm trying to place here. So, and it stems from the comment that if your lordship has said that this application is not right,
I've said that from the beginning, Mr. Moelo.
it was preceded by expert comment, my lord. The report will show that that was not the only, it was preceded by people commenting on the...
Mr. Moelo, I have said that. You either now deal with the instruction from your client, or you will file your replying affidavit, and this matter will be dealt with in terms of the rules of this court. A judge will be assigned to listen to your argument.
That it will be ventilated
In that deals.
There's no need to proceed with
Precisely. Precisely. No need at all. Yes, the criminal matter has already been postponed to the 10th of February 2025. The accused will be brought.